So the next case is In Re EP. Each party will have 15 minutes to present their argument. Counsel, how long would you like to reserve?
I'll reserve 5 minutes for the
All right, very good. I'll note that time is being reserved. You know the clock is up there, and you know, look at the top one. So I will try to let you know about a minute of your initial time. If you go over, it'll just come off your rebuttal time.
Yes, sir.
The arguments are, as you know, being recorded. Please stay behind the podium so we can see you, and please speak loud enough so we can hear you. If you're referring to any child like you've done in this case, please use initials or some other term. With that, we read your brief and ready to proceed whenever you are.
Thank you, Your Honor. May it please the court. Neil Agarwal for the appellant to juvenile. Your Honor, this is I don't want to say it's an easy case, but it's not complicated in any way. We're really here for a very simple reason. My client, being a juvenile, a delinquent, committed criminal damage. He was, for a prior delinquency matter, juvenile court put on an electronic ankle monitor bracelet for him through the Oriana program. And being a dumb kid, for a little better word, he cut it off and either lost it or destroyed the GPS unit. And there's no dispute that he did that. I mean, he got charged for a new delinquency, criminal damaging for the destruction or loss of this GPS unit, which he admitted to the offense, and they got sanctioned appropriately. We set it out for a restitution hearing, and at the restitution hearing, the state called one witness, somebody from Oriana House, and basically this gentleman said the cost for a brand new GPS unit with its accompanying ankle monitor strap is $600. And I asked on cross-examination, the unit that was destroyed, how old was it? I don't know. What condition was it in? I don't know. What was its fair market value? I don't know. What did you pay for it? I don't know. What was, can you give me some history or background of the unit that was destroyed? And basically he said, I don't know anything about the prior unit. All I know is the cost for a brand new replacement unit with the strap is $600. And the magistrate then awarded the Oriana House, the victim, $600. And I argued in front of the magistrate, and unsuccessfully, and to the judge and now before this court, that restitution is not measured by brand new replacement of the missing or damaged unit. It has to take into consideration the fair market value of what was destroyed or missing. And I said, and it's the state's burden or the victim's burden to prove what was the value of what was ever destroyed. Because victims are entitled to restitution and no one is disputing that Oriana is to be, get restitution. But they do not get a windfall. It's not an economic, hallelujah, we can get whatever we want. If I destroy your pickup truck in your business, or even privately, and your pickup truck is an old old beater car, and you go out and buy a brand new Ford, Explorer that's worth $100,000, do I have to pay you for the cost of the replacement property? Now, the statute does say you get replacement, the cost of replacement, but it has to be replacement that takes into consideration the wear, the tear, the depreciation. Okay, if I buy a flip phone, down at Walmart, $25 flip phone, one of those Obama phones, disposable, and you destroy it, and I say, oh, I'm going to go buy myself a brand new $2,000 iPhone with the latest bells and whistles, that's replacement value. Under the state's theory, absolutely. You would owe me $2,000.
I'm not sure that's replacement value for your flip phone to go to a brand new phone. And I appreciate what you're saying, your pickup truck analogy of, hey, I have a $2,000 beat up old pickup truck, and now I want a $40,000 new one. And I get that. So I think you're a little too far there, but so
yeah.
what we don't.
What I'm saying, Your Honor,
We're not, and in this particular case, we're not dealing with, as far as we know, any argument that they're asking for the greatest, wonderful, most wonderful ankle monitoring system in the whole world. They're just saying, look, that's what a new one costs, it's $600.
correct. But again, I'm going by the state's theory. When they say replacement value, they're not putting any limitation on it. And when I put in my example about an old phone to get a brand new one, they don't dispute it in any
Well,
way.
you could have cross-examined on that. As part of your cross-examination, did it lead you to believe they were asking for the new iPhone version of an ankle monitoring system, or were they just asking for a regular ankle monitoring system?
Well, Your Honor, they're asking for brand new. And,
I appreciate that.
right, what was the condition? Was it on, what if this was the very last time we were going to use this monitor on this kid? It was 10 years old, it had the oldest software, it was on its last legs, and when he returned it, we were going to dump it. And, you know, but hallelujah, he destroyed it, so we want the latest and greatest. And we want brand new replacement. And my argument is the magistrate has to take into consideration wear and tear, depreciation, and if you're going to buy replacement property, it has to be similar to the condition of what was destroyed property.
And I take it you would say in this case, because the person who testified for the state had no idea where it was in the use process, he couldn't say, you're right, this was 10 years old, or no, we just bought this 3 weeks ago and it's brand new, that they didn't meet their burden to show what the value was.
Correct. Now, if he would have got up and said, this unit's fair market value was, $600, we would not be here today. If he said, we just bought it, here's the receipt for it, we would not be here today. He couldn't testify about anything related to the old property, except the only thing he could testify is a brand new replacement is $600.
Counsel, the case law provides that the victim is not entitled to anything more than the actual loss. So your argument about the replacement value not necessarily being fair market value, isn't that limited by the case law that says it can't be more than actual loss?
Yes. The statute does say replacement property. And I agree. You can't get a windfall by buying the latest and greatest and saying, because if the limitation is the property is only worth $200, why do you get $600? And I agree with that. So yes. But what I'm saying is, if they can't prove valuation of the fair market value, and the state is saying, it says replacement value, so whatever the replacement is, he owes it, there's no limitation for that argument. And I'm saying that would be an economic windfall for the state. So, or not for the state, for the victim. So I'm saying it's their burden to prove what was the value of, at the time of the destruction, or even at the restitution hearing, this property had a value of X amount of dollars, that is what this kid owes. Okay, and they presented nothing except brand new replacement is this amount, and because they didn't present any of that, and I argued, they don't get any restitution, Your Honor, because they don't, what if it was worthless? What if the GPS unit that was destroyed had a fair market value of nothing? Again, we don't know because they presented no evidence as to the fair market value, the condition, its original purchase price, its wear and tear. They didn't present any evidence as to what was destroyed. The only evidence is what is the cost for brand new. And I'm saying that is unfair. Okay? No one is, again, arguing that Oriana is entitled to restitution, but it has to be just, it has to be reasonable, and it has to be related to the cost of the destruction. And then, and that goes really to my second argument is they didn't present any evidence, so they don't get restitution in this matter. And then the last argument, Your Honor, is the statute requires, or a statute requires 2152.20D. If a child is innocent, the trial court shall consider community service in lieu of the financial sanctions or restitution. And it specifically says shall consider. And in this case, what is the evidence that the magistrate followed the statute? Zero. Nothing was indicated on the record that the child's innocence affidavit was considered. And in fact, when I filed objections, the judge, and this is on A7 of my appendix, it says...
Sorry, we're down about a minute of your initial time.
Thank you, Your Honor. Even if the child was determined to be indigent, The Ninth District Court of Appeals has held that a trial court does not violate the statute when the record is silent as to whether considering imposing community service in lieu of a financial sanction. And they cite a case, but the case they cite, the trial court cites, does not support that proposition. So I would argue, and I cited a recent case from the Ohio Supreme Court, Ayers versus Ayers, where it determined about calculation child support, the trial court shall consider, and there was a silent record, and the Supreme Court said, a silent record, you can't presume the trial court followed the statute. There must be a finding. Here, there was no finding that the trial court or the magistrate considered the child's indigent affidavit. He was appointed counsel, he was indigent, and the case law says if a child is appointed counsel, he is considered indigent for purposes of the statute. So I'll reserve the rest of my time for rebuttal. Thank you.
May it please the court, Helen DiMartino on behalf of the state of Ohio, the appellee in this matter, we are asking that the court affirm the trial court's order of $600 in restitution to Oriana House for the replacement of the electronic monitoring device, which there is no dispute that the juvenile delinquent in this case did not return the device valued at $575 and destroyed the strap that was valued at $25. This is not a used vehicle. This is not something that there is a market that you could determine a fair market on. These are electronic devices that have to be carefully calibrated, constantly monitored, so that the information that is contained on the GPS is admissible in court. It is used for a wide variety of things. I believe this court can take judicial notice that we are talking about a GPS as opposed to even a Garmin that some citizen might buy at Walmart, let's say. And if it got damaged, there's a fair market of 1,000 probably different manufacturers of a device that works like a Garmin but isn't made by Garmin. These devices have to be the same one. They use one from Sentinel. If it's damaged, if it's lost, it gets replaced so that it is uniform and that every adult or juvenile who is on this type of electronic monitoring, we have the same device, we have the same data. There's no issue with admitting that into court or being able to say that this person is or is not within the zone that is determined by the court to be the appropriate zone in which they're allowed to be while they're monitored.
Counsel?
Yes.
As you said, from just common experience in the court system, I understand what you're talking about, but was there actually evidence presented in regard to any of that?
So the evidence that was presented was that they only use this device from Sentinel, and that when one is lost or damaged, they buy another one. It is all the same price. So the Constitution, the case law that's being cited, other that has to do with actual restitution by the appellant, those cases are all decided either before the constitutional amendment that went into effect on November 7, 2017, which Marcy's Law, the constitutional amendment, guarantees restitution that is full and timely to victims. And then the clarifying or implementation language for Marcy's Law that went into effect on April 6 of 2023. There's no dispute that the statute puts a cap on what the victims can receive. They cannot receive more than what was approximately caused by the damage by the adult offender or the delinquent. So there's no windfall, there's no hallelujah, there's none of the things that, you know, counsel is arguing about. In this case, we wouldn't put on evidence about a fair market value because there is no other market. They testified they just used the one device from the one company. It makes sense that they're all, you know, consistent. Because he couldn't tell the value at the time, you know, the condition at the moment that it was either destroyed or stolen by the delinquent is attributable to the fact that he had it last. So we don't know what the condition was right before he cut it off or right when he did whatever he did to it. The fact of the matter is while he had it, it was clearly working. So it was in a condition that was good at that time. There's no evidence, you know, that it was somehow malfunctioning. Even if it was old, there's no evidence that there's at some time the value to replace it would diminish. The statute that's in effect provides that the juvenile must be ordered to make restitution not to exceed the direct and approximate amount owed in 2152.2083. The expenses that are related to economic loss are what a juvenile offender's victim is entitled to under 2152.03. Economic loss is also defined by statute in 2152.203B, which is full or partial payment for the value of the property. And the value of the property is under 2152.203B, the replacement cost. And here the replacement cost, there is no dispute, is $600. While it might be fair for certain types of damages to consider a fair market value, there are just some things that inherently there is no other market other than replacement cost for it. And this is one of those type of things. There's no case law that says that the court is required to consider the fair market value. We have the Ohio Constitution as amended after Marcy's Law, and then we have the statute. And then he's got cases that are either before the constitutional amendment or the statute where they did consider fair market value, but it doesn't say that that is required, and if it is not done in every situation for every type of property, that that is error. With regard to the financial station, they're limited to a plain error review. The statute 2152.20D says that a court may order community service, does not have to. If the juvenile offender is indigent, then the court is required to at least consider it. And the court may consider it if the juvenile is not indigent. So there was, the record is silent. That is what the case law that is cited by the juvenile court says. If the record is silent as to whether the trial court considered imposing community service in lieu of a financial sanction, the court has not violated 2152.20D. The case law that he's citing now that has to do with child support payments is not going to be on point. Clearly, if the court has to make a finding and it doesn't do so, you can't presume regularity. This particular statute does not require that there's a finding. Therefore, if the record is silent as to whether or not the court considered it, this court can find that that was not an error. The juvenile also was ordered in that in the entry that the payments can be made through the Child Responsibility Project. The Child Responsibility Project is a program through juvenile court that helps juveniles obtain work so they can pay off their community service while also teaching them about accountability and consequences for their actions. So there is, while it's not community service, there is a program at juvenile court that will help this juvenile find the work so that they can make that restitution. And if there are no questions from the court, I would rest on my brief and argue that in this particular case, based on the device that is used, and the Constitution and the juvenile statutes that are in place under Marcy's Law, this victim was entitled to the cost of replacement. Thank you.
May it please the court. I really don't understand the citation of Marcy's Law. No one is disputing the victim's entitled to damages. And I don't think any of the statutes infringe, and they're not making an argument that the statutes of economic damages violate Marcy's Law or the Constitutional Amendment of Restitution. Remember, under the statute 2152.20A3, restitution shall not exceed the amount of economic loss suffered by the victim. So I don't think they're saying Marcy's Law supersedes that statute. So the question is, it comes down to, what is the economic loss of the victim? And she says, I didn't cite any cases about fair market value. If you look on page 6 of my brief, Your Honor, State versus Love, the Court of Appeals reversed the finding of full, it says, and I put it highlighted, the value of items that was purchased was the purchase price of new item, less the reduction in value caused by its use of depreciation, not the cost of buying a new item to replace a used item. And then I cite a number of cases from the first district where it was a destroyed vehicle, and the victim went out and bought a brand new vehicle, and the Court of Appeals says you don't get the cost of a brand new vehicle, you get the value of what was the destroyed vehicle. Okay? And again, Your Honor, whatever decision you make is going to affect every juvenile restitution case in this district, the 4 counties, but it will also impact adult restitution hearings too, because if you say it's full replacement value, then they can apply the same thing. And she's saying, the state is saying, well, just take judicial notice, this is a limited market. Well, this court can't take judicial notice. It has to take the case as it is. This is a destruction of a unit. What was its value at the time of the destruction? They don't know. What was the destruction at the time of the restitution unit? They don't know. What was its fair market value? We don't know. What was its condition? We don't know. They have to present some evidence as a destroyed item. They can't just say, regardless of the condition of the old one, here's our brand new item, we get it 100%, regardless of what the value was. And I don't think there's any case law that supports that whatsoever, because that is an economic windfall. That is an economic benefit to the state. And I understand Justice Stevenson said about the flip phone to an iPhone, that's a step too far, but why would it be? If destroying and getting a brand new car, why would that be a step too far? Under the state's theory, under their Marcy's Law argument, it doesn't matter. Replacement value is replacement value regardless of the condition of the old unit. And they're not putting any limitation on their argument. So, respectfully, Your Honor.
I was just thinking, you know, when you were arguing, because replacement value is kind of like a term of art, because in your insurance policy, you either get fair market value, you get replacement value. And so if something is stolen from my house, if my insurance policy says I get replacement value, that's a completely different thing.
That, I agree. In fact, your insurance will charge you more
Sure.
for replacement value than fair market value.
But what I'm saying is the statute could have said the fair market value, but the statute did say replacement.
Yes, but then it also says, it does say that, Your Honor, but it also then says, shall not exceed the economic loss. So I think, and again, I'm not saying they can't replace property, but it has to be like property for like property. So an example of the iPhone, if it's a 2015 iPhone that I destroy, you can't buy a 2024 brand new iPhone, get a 2016 or 14, get something similar. We wouldn't be here today if that was their argument. But to somehow say this old, maybe a 10-year-old GPS unit, you get a brand new 24 unit, I think that's unjust and unfair. And again, they have to present some evidence as to the value, and they said it's a limited market. We don't know that. And again, the case law is very particular. Any owner can say what they believe is the fair market value of the destroyed unit. So if I destroy your van, you come into court and say, Your Honor, in my estimation as owning this van, it costs $40,000. That is evidence the court can legally consider. But here, the gentleman from Oriana says, I don't know anything about the value of the old one. I'm only here to testify the cost of a brand new one. So respectfully, Your Honor, if they presented zero evidence of the destruction of the destroyed value, they have not proven what is their economic damages, or the victim is not entitled to restitution without any evidence as to that. Thank you, Your Honor.
Thank you. In behalf of the court, thank both of you for your presentation this morning. The court will take the matter under advisement and issue a decision in due course. When that decision is made,